Part 52. Impact on survivors. The grooming gangs destroyed the lives of hundreds of thousands of children. Survivors live with permanent physical and psychological damage that no institution has ever properly addressed. They carry lifelong PTSD, complex trauma, addiction, chronic pain, interrupted education, criminal records, lost children, and live with permanent fear. Many attempted suicide and sadly some succeeded. Others lost their own children to the same system that failed them. The state did not merely fail to protect these survivors, but it compounded the harm by criminalizing them, discharging them from hospitals without support, removing their babies, and leaving them in environments where the abuse could continue. The evidence shows a national pattern of lifelong devastation, inflicted on children who were sexually assaulted, trafficked, impregnated, and then abandoned by every agency meant to help them. Fiona was sexually abused repeatedly from age 13 while in care. She became pregnant at 15 and her child was removed for adoption while she remained in the same exploitative environment. Due to her abuse, she developed psychosis at 17 and mutilated her own legs with a blade because the gangs had complimented them during her abuse. She now lives with profound PTSD, substance dependency, and long-term physical health complications due to her abuse. Michelle suffered near daily sexual abuse from age 13, became pregnant 4 times as a child, endured miscarriages and a coerced abortion, and gave birth while still a teenager. She describes her childhood and future as destroyed, and she lives with PTSD that affects every day of her life. Chloe was sexually abused repeatedly from age 11, contracted multiple STIs as a 13-year-old, starved to 5 stone, drugged with heroin, imprisoned in her own home, and publicly humiliated. She now carries severe gynecological damage and lifelong trauma. Leanne was abused from infancy, trafficked, subjected to extreme violence including penetration by objects, strangulation, and backstreet abortions. She lives with profound physical injuries and a total lack of trust in every institution. Grace was groomed from early adolescence, molested while intoxicated, entered violent domestic relationships, and watched her own children abused. She suffers severe mental illness, displacement, and ongoing stalking. Kate endured a decade of trafficking, filmed blackmail, read rooms of torture, subjected to animal rape, and witnessed murders of other girls. She received an NRM conclusive grounds, but despite this, has received very little support and lives with trauma that she has to manage daily. Anna's recorded assault at 13 led to ostracism, an interrupted education, and lasting mental health damage. Jen was forcibly converted, married, and controlled under religious coercion, and she now has complex PTSD and lives in fear for her daughter. Leanne was held captive, beaten, and sexually abused while pregnant at 15. She miscarried, and now suffers chronic fibromyalgia and psychological trauma. Taylor was gang raped across multiple towns, and she carries lifelong psychological harm. Jane was trafficked from a care placement, developed a severe eating disorder, was sectioned, and left with lasting physical and psychiatric damage. Rachel's daughter, aged 12, was sexually assaulted and abused, bullied, and abandoned by police and school. She took her own life. Every survivor describes the same long-term consequences: destroyed education and employment prospects, broken relationships, inability to trust adults or institutions, chronic physical pain, addiction, repeated suicide attempts, loss of children, and a permanent sense of shame and worthlessness implanted by the gangs and reinforced by the state. The human cost is not abstract, but measured in ruined lives, lost futures, and children born into the same hell their mothers endured. Part 53. Conclusions. The evidence from high-profile convictions and compiled data on group-based child sexual exploitation indicates a clear overrepresentation of Pakistani Muslim men as members of the grooming gangs. However, when examining the religious dimension, often inferred from published names in court records and reliable reporting, the proportion of Muslim perpetrators appears even higher than the ethnic Pakistani figure alone would suggest. Analyses of conviction lists, such as those compiled by researchers reviewing cases from the late 1990s onwards, have found that approximately 90% of those convicted in relevant grooming gang cases bore distinctively Muslim names. A stark contrast to the roughly 6% Muslim proportion of the overall population. This pattern arises because nearly all documented Pakistani perpetrators in these cases have Muslim names, and additional convictions have involved Muslim men from other backgrounds, e.g., Somali, Iranian, Syrian, Turkish, and mixed groups with predominantly Islamic names. Non-Muslim participants remain exceptions, often isolated incidents in smaller or mixed groups. These recurring observations, drawn from judicial outcomes, inquiries, and other public records, establish a basis for advocating improved official data collection on the religion of perpetrators in group-based child sexual exploitation cases. Current national data frequently lack robust recording of ethnicity and religion, is even less systematically captured, limiting evidence-based analysis and responses. Enhanced, mandatory recording of both ethnicity and religion, alongside other characteristics, for suspects and convicted offenders in these offenses would enable clearer identification of patterns, better informed prevention strategies, and more proportionate policy interventions, while addressing long-standing criticisms of data inadequacies highlighted in government reviews and reports. The evidence heard by this inquiry is unequivocal, overwhelming, and devastating in its clarity. Organized networks of Muslim men systematically, sexually abused, trafficked, drugged, impregnated, and destroyed the lives of thousands upon thousands of British children across every region of the United Kingdom for decades. When the documented patterns from Rotherham, Telford, Rochdale, Oxford, Newcastle, Oldham, Huddersfield, Peterborough, Burnley, Tameside, and dozens of other towns and cities are extrapolated nationally, the scale reaches at least 250,000 victims. This is not a collection of isolated local scandals. It is a national scandal of industrial-scale child sexual abuse and modern-day slavery, enabled, protected, and prolonged by the deliberate failures of the British state at every single level. The testimony of the survivors and their families leaves no room for denial or equivocation. Sally watched her daughter's life unravel. Although her daughter has admitted to lying on occasion, the police privately acknowledged grooming, yet in public communications treated her only as a liar. Marlon had his parental authority stripped away, so that his daughter could be returned to the very place where she had been molested. Whitney's reports of exploitation were dismissed while her own childhood trauma was used to undermine her credibility as a mother. Rachel saw her 12-year-old autistic daughter discouraged from pursuing justice, bullied relentlessly, and ultimately driven to her death by an overdose after the authorities failed her at every turn. Fiona, Michelle, Chloe, Marie, Grace, Kate, Anna, Jen, Leanne, Taylor, Jane, Lily, and so many others described the same relentless pattern: repeated sexual abuse, gang rape, blackmail with filmed abuse, pregnancies used as weapons of control, miscarriages, coerced abortions, and the birth of children who entered the world already condemned to the same cycle. These were not all vulnerable children, in the narrow sense the authorities preferred to believe. Some came from stable homes, middle-class families, and loving parents. The perpetrators targeted them precisely because they were unguarded by the collective male protection that some minority communities could mobilize. The gangs operated under an honor and shame-based clan code that treated non-Muslims, especially white working-class girls, as property available for sexual use. They transported victims between towns, shared them among brothers and friends, forced conversions to Islam followed by unregistered religious marriages, and justified the abuse by describing the girls as easy meat, white trash, or morally inferior. The same networks targeted Sikh girls, until Sikh communities responded with collective male protection. White girls received no such defense. Every institution that existed to protect children instead enabled the gangs. Police forces across England and Scotland discouraged reporting, criminalized victims, destroyed evidence, allowed known perpetrators to walk free on bail, and in some cases actively participated in or shielded the networks. Social care removed parental authority, placed children in trafficking hubs inside children's homes and semi-independent units. Closed cases, despite clear evidence of exploitation, destroyed records, and retaliated against whistleblowers. The NHS recorded genital injuries, multiple STIs in 13-year-olds, pregnancies caused by sexual assault, and suicide attempts, yet discharged the children back to their abusers the same night with no safeguarding or trauma care. Schools watched older men collect girls at the gates, heard disclosures of sexual assault in toilets, and excluded the victims rather than protecting them. Taxi licensing authorities renewed permits for the very drivers who formed the logistical backbone of the trafficking networks, and collapsed in the face of organized protests when basic safety measures were proposed. The media self-censored the ethnic and religious pattern for fear of being labeled racist. Social media platforms became the primary tools for initial grooming, distribution of sexual assault videos, and coordination between perpetrators. Politics, especially the Labour Party, bears the heaviest responsibility. Councillors and MPs sat on the very authorities that covered up the abuse. They were briefed as early as 2003 through the CROP multi-agency group, yet later denied knowledge. When finally forced to act, the Labour government produced a national inquiry whose terms of reference were so tightly drawn, limited to group-based child sexual exploitation, in a handful of relevant local areas, time-limited, and deliberately excluding any systematic examination of the demographic, cultural, and religious drivers, that it could not possibly confront the truths that this inquiry has heard. Labour did not merely fail to protect children, it actively obstructed justice, suppressed ethnicity data, voted against a proper national inquiry, and sacrificed tens of thousands of white working-class girls on the altar of multiculturalism and electoral arithmetic. The Conservative Party, while in national government from 2010 onwards, also failed. It did not impose mandatory ethnicity recording, nor did it launch a nationwide statutory inquiry despite the Rotherham J report and other revelations. Rory Stewart, a former Conservative minister, publicly described the issue as a small problem confined to the north of England. He downplayed the national reality and thus showed the attitude of, at the very least, a section of the party. Scottish politics mirrored the same reluctance, refusing a dedicated inquiry and failing to record offender ethnicity. The human cost is incalculable and permanent. Survivors carry lifelong PTSD, complex trauma, addiction, chronic physical pain, interrupted education, criminal records, lost children, and unrelenting fear. Many have attempted suicide repeatedly, and some succeeded. Others lost their own children to the same, failing system that failed them. The gangs used pregnancy as a deliberate weapon of control, and the state compounded the harm by removing babies for adoption or placing them in care, while abandoning the young mothers in the environments where the abuse continued. Intergenerational trauma has been institutionalized. The state recorded the injuries, the STIs, the pregnancies, and the disclosures, yet chose votes. So-called community relations, and fear of racism accusations over the protection of British children. Whistleblowers who tried to expose the truth, such as a social worker, Cavan Vines, Tommy Robinson, and countless protective parents were suspended, bankrupted, subjected to dawn raids, asset freezing, and gagging orders. The rule of law failed, and racial and religious aggravation was almost never applied to the few that were convicted. Foreign national offenders were rarely deported, and sentences bore no relation to the lifetime of destruction inflicted. This inquiry has heard the testimony. It has seen the documents. It has recorded the names of officers, social workers, counsellors, ministers, and institutions that failed. The evidence is now overwhelming and irrefutable. The grooming gangs did not operate in the shadows, but with the active or passive consent of the British state. The betrayal was total. Part 54. Recommendations. The evidence presented to this inquiry by victims and whistleblowers demonstrates beyond reasonable doubt that the grooming gangs operated with either the active or passive consent of public authorities. More or less, every institution failed. The state knew the patterns, recorded and then often destroyed the evidence of harm, and chose political convenience over child protection. Any government that aspires to restore justice, eliminate the gangs, and protect the next generation, must implement the following recommendations. Only then can the British state begin to make up for its profound betrayal of hundreds of thousands of British children. Criminal justice response. Victims must be placed at the centre of the criminal justice process. They must have the right to be informed of all decisions, to attend sentencing hearings, and to submit victim personal statements that carry statutory weight. Independent sexual violence advisors must be funded nationally and assigned to every grooming gang victim, from the moment of first report. Sentences. Current sentencing guidelines are grotesquely inadequate for organised child abuse. The Sentencing Council must be required by statute to revise its guidelines so that group-based child sexual exploitation carries a starting point of life imprisonment, with a minimum tariff of 50 years for ringleaders and 25 years for participants. Racial or religious motivation, multiple victims, trafficking across counties, pregnancy caused by sexual assault, and use of filming or blackmail must each be spelled out as statutory aggravating factors that push sentences toward their maximum extent. Concurrent sentencing must be prohibited where multiple victims are involved, cumulative sentencing must be the default. A number of politicians, including Rupert Lowe MP, have also called for a referendum on reintroducing the death penalty for the most heinous crimes. There is a case to be made that this is more than proportionate, where grooming gangs are concerned. Immigration, deportations, and denaturalizations. Every foreign national convicted of group-based CSE must at the very least be deported. Any British citizen convicted of these offences, who holds dual nationality, must lose their citizenship automatically upon conviction, rendering them liable for deportation. This ought to apply retrospectively to those convicted in the past too. The Home Office must publish annual deportation figures, broken down by national background and offence type. Where a perpetrator has family members in Britain, who have supported, harboured or failed to report the offending, the entire immediate family unit must also face deportation proceedings themselves, unless they can prove either active cooperation with authorities or no prior knowledge. The evidence from witnesses, convictions, and the KC audit shows a clear overrepresentation of Muslim men, particularly of Pakistani heritage, in these organised networks. The inquiry has not ignored this. Mosques, madrasas, and community organisations that have harboured or failed to report perpetrators must face investigation and, if found guilty, be closed. The immediate deportation of anyone nested within such subcultures, promoting attitudes that dehumanise non-Muslim girls, must be pursued. The nations of the world are not identical. Ultra-selective border control, attentive to general patterns in sending countries, is therefore also vital to the long-run happiness and continued existence of host peoples across the West. Immigration policy must immediately reflect the evidence. Anyone from a country whose nationals are disproportionately represented in grooming gang convictions must no longer be entitled to a visa. This should be applied ruthlessly. Our young girls must come first. Children giving evidence. Special measures for child witnesses in grooming gang trials must be strengthened. Pre-recorded evidence, remote testimony, and screens must be the default. Cross-examination that re-traumatizes the child must be prohibited. The court must appoint a specialist intermediary in every case. The Crown Prosecution Service. The CPS must create a dedicated national unit for group-based child sexual exploitation, with specialist prosecutors trained in trauma-informed practice. Charging decisions must no longer be influenced by community impact or fear of racism allegations. Failure to charge a clear case must be reviewable by the Attorney General and should result in criminal liability for those who do not carry out their duty. Overseas Task Force. It has been established that organized gangs, chiefly of Pakistani heritage, have not only groomed, sexually abused, and tortured thousands of women and girls across Britain, but have also trafficked such victims overseas, particularly to Pakistan and other countries. Evidence from independent hearings, early-day motions in Parliament, and of course survivor testimonies presented to this inquiry, serve to suggest as much. The intent by perpetrators was to exert near total control, prevent disclosure of the abuse, obstruct homegrown investigations, and continue inflicting abuse in environments with weaker safeguards. The full extent remains under-investigated, due to historical institutional failures by police, councils, and social services, often linked to concerns over racism allegations or inadequate cross-border cooperation. This must be rectified. It is therefore recommended that a dedicated task force be established within the Foreign, Commonwealth and Development Office, FCDO, working in close liaison with the Home Office, police forces, the National Crime Agency, and international partners. This unit should prioritize the identification, location, safeguarding, and urgent repatriation of affected British women and girls. That means enhanced consular support, intelligence sharing on missing persons cases recorded in known grooming hotspots, targeted reviews of passports and travel records linked to known perpetrators, and diplomatic pressure on destination countries for victim extraction and evidence gathering. Compensation. A national compensation scheme for grooming gang victims must be set up at once. Something similar already exists in the form of the Criminal Injuries Compensation Authority, CICA, established in theory to seek compensation on behalf of people physically or mentally injured because of a violent crime in England, Scotland or Wales. CICA does so by suing authorities or perpetrators directly, but has proven time and again to be unfit for purpose in all sorts of ways. Despite providing evidence that helped to convict the leader of a Rotherham-based grooming gang, Sammy Woodhouse was refused compensation by Seeker on the grounds that she had consented to her own abuse. In our view, awards should be updated to reflect the lifelong harm documented in survivor testimony, including loss of education, employment, mental health, physical health, and family life. The scheme must be funded by a levy on all convicted perpetrators' assets, and by the defined benefit pensions enjoyed by any public servants, either within police forces or social services, found guilty of or dismissed for culpable negligence. Family. The law must place the protective family at the center of safeguarding. As such, the core principle that should underpin safeguarding reform is recognition that a child's family tends to represent the first, strongest, and most effective line of defense against exploitation. While there are circumstances in which children cannot safely remain within their family unit, exploitation cases generally differ from traditional intrafamilial abuse models. Present safeguarding systems do not always reflect this distinction. Families may experience responses that frame them primarily as contributors to risk, rather than as potential safeguards against it. This can result in reduced trust between families and professionals, parental disengagement from safeguarding processes, delayed information sharing, increased isolation of the child from protective relationships, and perpetrators exploiting divisions between children, families, and agencies. Official research increasingly reinforces relational approaches to CSE, recognizing that protective networks, including parents, siblings, extended family, schools, peers, and community relationships, are central to reducing vulnerability and disrupting exploitation. Once removed from family and community networks, children as a general matter become more vulnerable to grooming, missing episodes, trafficking, and other forms of harm. A family-first approach is therefore essential. We recommend the construction of a safeguarding framework, in which families are recognized as primary protective factors wherever safe. Family support is prioritized, contextual safeguarding approaches are strengthened, and residential care is used proportionately and as a last resort, rather than as a default response to exploitation risk. This proceeds from the understanding, bolstered by our inquiry, that where grooming gangs are concerned, parents and carers are more often protective than causative agents. Needless to say, this family-first approach should never prevent decisive intervention in cases where home environments are deemed unsafe. The point is that safeguarding authorities must first establish the unfitness of some family environment before residential placement becomes the response. Parents ought also to have a statutory right to be informed of all risks to their child, to receive copies of all assessments and plans, and to challenge any decision that undermines or removes their parental responsibility. Financial and practical assistance, including emergency housing relocation, where needed, must be made available to any parent reporting grooming indicators. The state should not interfere with a family's ability to protect itself from harm. Part 55. Legislative response. The existing legislative framework is fragmented, inconsistently applied, and deliberately blind to the ethnic and religious patterns documented in this inquiry and the Casey National Audit. As we have noted above, the Sexual Offences Act 2003 and the Modern Slavery Act 2015, among other relevant statutes, already contain powers that were never used to any significant effect against the grooming gangs. Ethnicity recording, too, remains either patchy or absent. Group-based child sexual exploitation is not even a distinct offense with its own sentencing guidelines. The result is a system that records thousands of individual offenses while concealing, deliberately or otherwise, the organized nature of the predation. A single, comprehensive Childhood Sexual Exploitation Act must be enacted at once. This new statute should create a specific offense of organized group-based child sexual exploitation, understood as participation in networks that groom, traffic, or exploit children for sexual purposes, whether or not each individual act can be separately proven, with mandatory minimum sentences and aggravating factors for racial or religious motivation. It must reverse the presumption that a child can ever consent to sexual activity with an adult, especially in a grooming context. Courts to date have recognized that apparent acquiescence may be the product of coercion or psychological manipulation, but the statutory formulation has not fully reflected this aspect of CSE. It must also impose a statutory duty on every relevant public authority to record and publish the ethnicity, immigration status, nationality, and religion of both victims and perpetrators in all such cases. This would entail speedy repeal of any legislation that forbids authorities from collecting relevant ethnicity and religious data. Last of all, it must criminalize, as we shall elaborate below, any provably culpable failure or refusal on the part of public officials to act on grooming gangs for fear of inflaming community tensions or inviting anti-racist media scrutiny. This would build upon existing principles concerning misconduct in public office, but provide clearer and more enforceable standards. Parliament should mandate enhanced sentencing for offences committed as part of organised networks, including minimum custodial terms and expanded use of whole life orders in extreme cases. The gravity of such offending, often involving prolonged abuse, trafficking, and commercial exploitation, justifies the harshest possible sentences. A broader constitutional question arises concerning the interaction between human rights law and the prosecution of organised sexual exploitation. It is frequently argued that existing rights frameworks have been interpreted in ways that inhibit robust enforcement or contribute to institutional caution. A comprehensive review of the Human Rights Act 1998 should therefore be undertaken with a view to recalibrating the balance between individual rights and the protection of vulnerable victims. Reforms should focus on ensuring that rights-based arguments cannot be deployed to obstruct investigations, prosecutions, or deportation proceedings involving serious sexual offending. Indeed, it is probably preferable to repeal the Human Rights Act 1998 than to allow it to continue in its current form. The Equality Act 2010, if not repealed altogether, should never be applied to criminal justice and safeguarding contexts. Anti-discrimination principles must not operate as a deterrent to the identification of risk patterns or the enforcement of criminal law. Short of full repeal, at the very least legislative amendment should clarify that equality protections can neither be invoked to shield criminal conduct, nor to restrict lawful investigative practices based on evidence-led risk assessment. Preventative mechanisms must be significantly expanded to address the evolving nature of child sexual exploitation and organized grooming networks. At present, the criminal justice system remains heavily reactive, intervening most decisively only after serious offenses have already occurred, and victims have suffered lasting harm. While prosecution and punishment remain essential, greater emphasis must be placed on early intervention, disruption, and risk management in order to prevent abuse before it escalates. One vital reform would be to ensure the wider and more proactive use of sexual risk orders and related civil preventative orders. In principle, these powers allow authorities to impose restrictions on individuals who demonstrate concerning behavior characteristic of sexual abusers, even where a criminal conviction has not yet been secured. Greater readiness to deploy them would give police officers and safeguarding agencies more confidence to intervene sooner rather than later, whether by restricting contact with vulnerable children, monitoring online activity, limiting access to certain locations, or preventing association with suspected grooming networks. Such measures would help close the gap between suspicion and prosecution, where many offenders currently continue operating unchecked. For similar reasons, compulsory monitoring arrangements for high-risk offenders should be strengthened. Individuals with histories of sexual violence, exploitation, trafficking, or organized abuse should be subject to more rigorous supervision through electronic monitoring, regular risk assessments, mandatory disclosure requirements, and closer multi-agency oversight. Given the increasingly digital nature of grooming, monitoring should also include online behavior and communications, where legally proportionate. Enhanced supervision would not only reduce opportunities for reoffending but also improve intelligence gathering on wider criminal networks. Mandatory reporting duties for institutions represent another crucial preventative safeguard. Schools, social services, healthcare providers, care homes, charities, and other organizations working with children should be placed under a clear legal obligation to report suspected abuse, exploitation, or grooming activity to the appropriate authorities. Too often, institutional failures, fear of reputational damage, or uncertainty about procedures have allowed warning signs to be ignored. A statutory duty would create greater accountability, encourage earlier referrals, and strengthen interagency cooperation. Failure to report serious concerns, particularly by professionals in positions of trust, should carry meaningful disciplinary and potentially criminal consequences. Expanding preventative powers must, however, remain consistent with principles of proportionality, due process, and basic freedoms. Safeguards including judicial oversight, regular review mechanisms, and clear evidential thresholds are necessary to ensure that expanded powers are not used arbitrarily. Nevertheless, Where the protection of vulnerable children is at stake, the balance of public policy should favor earlier intervention rather than waiting for irreparable harm to occur. Finally, the overarching legislative objective should be to recognize organized sexual exploitation as a form of structural criminality. This requires a shift in both legal doctrine and institutional culture. The law must move from reactive punishment to proactive eradication of networks that exploit vulnerable children. Without such a shift, existing statutes, however numerous or severe in theory, will continue to operate as instruments of retrospective justice rather than effective protection. The following principles must be enshrined in the aforementioned Childhood Sexual Exploitation Act. Children can never consent. The Act must prohibit any agency or court from treating a child's previous behavior, clothing, intoxication, or lifestyle choices as mitigation or consent. Any professional who uses such language in reports or proceedings must face disciplinary action and potential criminal sanction. Accountability encourages competence. The Act must contain greater clarity in law, detailing the positive expectations to which public-facing bodies with a statutory duty of care must be held accountable. Among frontline professionals, it is of course everybody's duty to safeguard children. The clarification should be such as to require the relevant duty holder, be it an individual, an organization, or some other entity, to take proactive, affirmative steps to save children from group-based exploitation. Breach of this duty, whether by provable incompetence or deliberate malpractice, must be an offense. Repeated failure to act on known safeguarding indicators has been one of the defining characteristics of the grooming gang scourge across Britain. Public bodies must therefore face clear legal accountability where serious neglect occurs. Crimes committed by child victims of grooming at the behest of their abusers lack the mens rea, guilty mind, to count as criminal in the conventional sense. The Act must expunge the criminal records of any child or young person convicted of crimes, including prostitution, drug possession, or public order offenses, that occurred, while and because they were forced to do so. The presumption must be that such convictions were the direct result either of manipulation or coercion. Named Sammy's Law, after Sammy Woodhouse, this would be for the benefit of survivors in need of closure, who were criminalized instead of protected. Proven sexual abusers forfeit their parental rights. The Act should make it unambiguous that sexual abusers, upon conviction, automatically lose their parental rights over any children born of such sexual abuse. Sharia marriage. The Act must prohibit Sharia marriages. Too often, these have served as a pretext for abusers to exercise greater coercive control over their victims. This is because Sharia courts effectively operate as a parallel judicial system, recognized in British law, but not of British law. This enables them to govern the life of Muslim communities and by extension the life of any victims groomed by such communities, in ways counter to our long-established norms and customs.